an NSF fees. So you are allowed to charge them a $35 NSF fee. That would come to you for the inconvenience, but you're also allowed to add the bank charge of the NSF fee. So if your bank charges $25 for the return check, they're basically looking at a $60 monthly fee for that. Again, back to the non-compliance fees. So if you're not sure what fees you're allowed by law to charge and how to do it, number 24 is very important to go through. And I'm not going to cover every one of them here, but you'd definitely want to look through this before you start charging any other fees. Because if it's not listed here, you're not charging it. And this is a further explanation of the early termination fee. And number 26 is HOA assessments. So this was designed because if you, for example, rent a condominium and they have a what's called an elevator fee, and these can range, they can go up to $600-800 for move-ins. And if it's handled properly, the landlord basically has to pay that fee, but that is something that can be billed back to the tenant. Of course, you'd want to disclose that in your advertising for the unit. So that's what this is for, is specific assessments that are designed for move in, move out by HOAs. Application of payments, and again, this is one that has been updated for until February 28th on our notice. And so you want to make sure that you understand that, because in the original or the normal agreement, if you get a lump sum, if your rent's $1,000 and you get $2,000, the first $1,000 could be charged for outstanding rent from prior months, and then you can charge the current rent. So this is the order in which that money is accounted for. During the emergency period, or until February 28, 2022, when you get a lump sum by law, the first amount has to be charged to current rent. And that's designed so that if they owed a COVID rent of $10,000 and they paid you $1,000 for this month's rent, and your rent charge is $1,000, then it doesn't go back to the COVID rent, because that's still within a grace period, and you're by law required to put that money first to the rent before it covers any utilities, any damages, any late fees, any maintenance owed. So make sure you pay attention to this very simple, benign little clause that could come back and clip you if you don't do it right. Rent increases are allowed in accordance with applicable laws. What are those laws? Those are on the forms that will cover that at a later date. Attorney fees, pretty important, because if you do get into a legal spat, the prevailing party will be able to charge lawyer fees. So I'm going to just take a quick editorial here. If the tenant owes you $250 for some reason and they never pay it, and you decide to pursue it, and they hire a lawyer and you hire a lawyer and you're paying your lawyer to defend your action, this is very hypothetical, but the bottom line is, even if you win that case, you've already paid the amount of money, the $1,000, $1,500, $2,000, $10,000, fill in the blank, for your legal fees. You win the case against the tenant, and you still have to then collect from them. And it's widely recognized that when amount is owed from a tenant, they are very difficult to collect on. So before you make any legal action, really weigh the pros and cons of your risk and reward. So that's my little risk management seminar here. Insurance, tenant maintains rental insurance. Now, this number 31 explains what that tenant rental insurance policy covers. And it's a long clause. And what you're going to find out, it doesn't cover what you want it to cover. But it does cover them for a lot of things for them, for their stuff, if it gets stolen, or if they need temporary housing because of something like a kitchen fire that had to be fixed and they couldn't live there, or there were some issues. So it's very important the tenant has insurance, but it doesn't necessarily protect the landlord to the degree that it used to before the law was changed. The enabling clause allows you to retain control over common areas if you have common areas in your premises for the purposes of trespassing. So you can exclude non-tenants from your property by law. Non-waiver is, succeeding breaches which shall be accepted rent during any period in which the tenant is in default. So if the tenant owes you money, they still owe you money. Joint and several liability, when there's multiple tenants, roommates, it's one equals all. So if one moves out, basically they're all saying they're moving out. If one owes you money, they all owe money. If one moves out, there's a security deposit held on the property. The security deposit is held until the unit is completely vacated. So there's one occupancy, no matter how many tenants there are, if you use our agreements. If you're going to report any breaches to credit reporting, you have to let them know. I'm going to read this one out loud because I don't remember what it is. If any clause or provision of rental agreement is illegal, invalid, or unenforceable under present or future laws effective during the term, then it is the intention of the parties hereto that the remainder of this rental agreement shall not be affected thereby, and is also the intention of the parties to this rental agreement that in lieu of each clause of provision that is illegal, invalid, or unenforceable, there be added as a part of this lease a clause or provision similar in terms to such legal, invalid, or unenforceable clause or provision as may be possible and be legal, valid, and enforceable. So what does that mean? Well, let's go back up one. Credit reporting. Under the temporary guidelines for the COVID period, landlords cannot report to credit agencies any rent owed between April 1st of 2020 and June 30th of 2021. So there is something that's changed since perhaps this rental agreement was signed and authorized. But it doesn't invalidate the entire agreement. There has to be something in place that would address that issue, and that is the notice that we have what we provide as well. Now, the last part of this is the addendums, and the addendums equal part of the entire agreement. So it's not a rental agreement plus addendums. Each of these that you decide check become part of one agreement that would be used in any action to pursue cause on any of the items. So you're going to look through these. These are we've covered these in another video, and you want to mark the ones that you're going to add to your tenancy. Lastly, is the emergency contact information. Excuse me, I'm going to take a drink. This is nothing to get choked up about. Excuse me, but what this means is that you want to make sure you have somebody that you can reach out in the event of a death of a tenant. It sounds completely far-fetched, but it isn't. We all end up there sooner or later. And in order to process the entire move out and handle the complexities when there's a death, the notification is very important. So this is one of those little details that can be overlooked, but please don't.